We're in Unit 6, Forms of Ownership. Okay. So the choice of ownership has implications. Okay. The choice of ownership, how you decide to take ownership, Jacob, has implications. The ability to transfer the real estate, tax consequences, and even rights to future claims. Licensees should encourage buyers to consult an attorney to help them decide how they're going to take ownership of the property. Okay? You should not give the advice. You can take ownership in severity, where it's just one person, co-ownership, more than one person, or even in a trust, you can take ownership. Let's talk about ownership and severity. One person or one corporation. The owner has the sole right. Got your attention back here, huh? You own this property in severity. You have the right to sell it. You have the right to will it. You have the right to lease it. And any transfer to another person. You have that right. You own that property in severity. Just you. You can make all the calls on it. Okay? Co-ownership, held by two or more people. What's that? See, that 7 still give me trouble, Andrea.
Yeah, because that was that animation.
You're gonna Google that and figure that out for me. Co-ownership would be held by 2 or more people. Okay, so there's several ways you can do that. You can do that as tenants in common, and we're going to get into these, and they're a little confusing, but I'll try to help you decipher them. Joint tenancy, tenants by the entirety, or community property. Typically, these characteristics don't affect the use or occupancy of the property. Differences arise with alienation. What's alienation? What's the term alienation mean? Look it up. Put your hand up when you get to it. What's that?
What did you say before alienation?
Look it up in a book. Let me know what it means.
I see alienation clause.
Yeah, what's it say, Christine?
The clause in the mortgage that states that the balance of the secured debt becomes immediately due and payable as the mortgagee option if the mortgagor sells the property.
Okay, so difference arise with alienation and disposition or conveyance. Okay, alienation means that tell me if I'm wrong. I mean, come on, man, you guys got to start showing me that I'm just not faking it until I'm making it here. Doesn't alienation mean that if you sell the property, and if somebody has a mortgage, you got to pay it off? Isn't that the alienation clause? I don't know. No?
So that's like if someone, like if there's a balance.
I would assume that's what it means. I would assume, yes, that's what it means. Okay. So the different forms of co-ownership. Tenants in common, joint tenants, tenants by the entirety, and community property. So let's talk about tenants in common first. See if I have a handout. I don't. Okay. So tenants in common, if we look at the picture on page 91, okay? A and B are tenants in common. So they both buy a piece of property. B dies and wills his interest to C and D. C and D then would be equal as tenants in common. Okay? So
I have it here, but I have to email it to you.
what's that?
I fixed it.
Okay.
I just have to email it to you.
Email me the fix.
Yeah, the whole PowerPoint. Because I don't have Dropbox on my computer
Right.
and I can't upload it.
Can you fix it during the break?
It's already fixed.
Okay. So what case would we use tenants in common? Let's say, let me go back because I haven't been bugging the boys. Let's say Garrett and Jacob buy a place on the beach. You guys aren't married. Okay. And you're going to buy it as tenants in common where you each own 50% of it. Okay. And you just want to take title as tenants in common because if Garrett decides he wants to be able to sell that piece, or when he dies, he wants to be able to will that to his children, so his children could use that vacation. So that would be, so you two guys are buddies, and you say, let's buy it. We'll buy it as tenants in common. I'll own half, you own half, and if something happens to you, you could will your half or sell your half to somebody else. Now, you both have, it doesn't interfere with the right to use it, just the conveyance. Okay? Just the conveyance. So you would have to work out the schedule yourself. Then there's joint tenancy. So that's when two or more deed does not indicate the form of ownership. The new owners usually are usually determined to have acquired title as tenants in common. Okay. Now joint tenants. Flip over to the next 92. Joint tenants with the right of survivorship. Okay. So now Jacob, Jason and Garrett, all three buy this vacation home. Your three buddies. You buy a vacation home. Then you say, what we're going to do is, we're going to buy it as tenants in common with right of survivorship, and the last man standing out of the three of us gets the property. Do you see that happening? So something happens to Garrett. He passes away. He's out of the picture. Now the property is owned as tenants in common, was a joint tenancy with right of survivorship by you two guys. And then Jacob passes. Now Jason owns that property all by himself. Now Jason, when he dies, he has two siblings, Christine and I'm struggling with this. Sorry. Okay, when you pass away, then you can will that to your two kids, and then they would be his tenants. Isn't that the way the instructions say in the book? Okay. So, maybe there's a case where somebody wants to buy a vacation home, their buddies, there's 2 or 3 of them, and they say, let's buy this vacation home. Last man standing gets the vacation home. And Jason's the last man standing, and since he owns it now in severity, because he's the last guy, right? When something happens to him, he can will that to.
Is it possible for one of them to change the deed and add a tenant in common, or?
No. Nope. No. No.
What do you call that?
Well, wait a second. Let me look here.
I have a deed.
So if you look at C, to create joint tenancy with the right of survivorship, you have to have certain things. And there's 4 unities. Unity of possession, meaning they all took title, all 3 of those guys at the same time. Unity of interest, they all own the same interest. Unity of time, they all acquired that interest at the same time. And unity of title, meaning they used one document. And the 4 requirements for unity are as follows. Title is acquired on the same document or deed. The title is executed and delivered at one time. The deed conveys equal ownership to all parties, and the parties hold undivided possession. Excuse me, let me shut the phone off. So tenants in common, ownership by 2 or more people, undivided fractional interest. The owners must have unity of possession, meaning they all have a right to use the property. Ownership interest, not property, is divided. So if all 3 of those guys are tenants in common, Jason doesn't get one room, Jacob doesn't get another, and Jared doesn't get another. All 3 of them have a right to use the whole property. Okay? Can be equal or unequal interest. Can say, sell, convey, mortgage, or transfer without the approval of the other. A death or ownership interest passes to their devisees. So the show Selling LA weekend, Sunday as a matter of fact. And this company, California, buys these like $10 million homes. And then they sell an interest. They would use tenants in common to like 8 people. And all 8 of those people now have a 1/8 interest in that unit. Now, doesn't that kind of sound like a timeshare? But the difference is they can sell their interest at any time to somebody else without the approval of anybody else. And that's a pretty unique way, because these are like $10 million homes. One was $5 million. But if they divide that up into 8 different people, and these are more vacation homes, like out in the country. Okay. So that's where tenants in common would come in play. And in Pennsylvania, if the deed does not stipulate the tenancy, 2 or more owners become tenants in common. Unless conveyance is made to husband and wife, and then they would be tenants in the entirety. So joint tenancies. What's that?
I don't understand.
Tenants in common. Tenants in common. That all 3 have the same interest in the property.
Yep, I get that.
And they could sell, deed, or mortgage, or will their interest.
Right.
Okay? The joint tenants with the right of survivorship, they can't. So if they were joint tenants, they can't sell their interest. Joint tenancy with the right of survivorship, if there's 3, then it would go to 2 when one dies, then it would go with 1, and then that person owns it as severity. So joint tenancy with the right of survivorship, they can't sell or mortgage their interest individually. Tenants in common, they could. That's the 2 differences between those 2. That's the 2 differences. Go ahead.
A tenancy in common, you can have, you say equal or undivided parts, but a joint tenancy, they're all equal?
Yes. 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 So with joint tenancy, you have to have the 4 unities. And it's PITT, PIT, possession, interest, time, and title with joint tenancy. Title is acquired by one document or deed. The deed's executed and delivered at one time. The deed conveys equal interest to all parties. The parties hold undivided possession of the property. So any one of those guys could use the place anytime they wanted. Now, joint tenancy with the right of survivorship. The surviving tenant acquires the interest of the deceased tenant. The joint tenant continues until one ownership remains in severity. So that's how you have to remember it. So maybe we need to break this thing down so that you guys can visualize it. Those 3 coconuts back there. Joint tenants with the right of survivorship. They buy a place down here in Miami. It's a condo. And your 3 buddies, they're drinking buddies. They're saying, we're going to buy this joint tenants with the right of survivorship. Last one standing, last guy living, he gets the place all to himself. So they all 3 own it. They have to take title, PITI, possession. What was the PITI? Look in the book. They have to take possession at the same time. They all have to have the same undivided interest. They have to do it at the same title. And what was the other? Time. They all have to do it at the same time. So these guys are tenants, joint tenants with the right of survivorship. Okay. Passes away, he gets the property, he owns it in severity. These 2 guys are buying a piece of property. As tenants, gotta make sure I use the right terminology, in common. Okay? So if Sheila wants to, she can sell her interest. Could these guys as tenants quit selling? Could you? No. You could. Here's your tenants in common. You could sell it, and if something happened to you, you could will it to your heirs. You guys couldn't do that.
Couldn't they add, like, take their part of the deed and add somebody on it if they would own it with them?
Who? These guys or you?
These guys.
No, because they have to all pay title at the same time. That's the difference with that type of tenancy. Joint tenant, they all have to do it at the same time. You guys could. You could sell yours, Tam, to Vonnie.
I have a deed that's the right of survivorship. It was between my husband and his sister.
Okay.
My husband found out he had 2 weeks to live. So he took it, we went to the lawyer, and I was added on to his part of the deed. When he passed away, it all went to me.
Then I would assume you did not have joint tenancy with the right of survivorship. What you had was tenants in common. No right of survivorship with tenants in common. You had tenants in common.
I have the right of survivorship too.
That's because you went to an attorney and he put you on that. Okay. So tenants in common, you don't have the right of survivorship. You can do whatever you want with your piece. So your brother, your husband and his sister owned the property, probably as tenants in common.
But it did have a survivorship thing on it.
It could have had some kind of thing, but
She's an attorney, so she had it all.
yeah, don't get confused with it. You guys are tenants in common. You can sell your interest to somebody else. Those guys are joint tenants with the right of survivorship. They can't. Last guy that gets it gets it.
Because they're joined together.
Because they're joined together with the 4 unities. Joint tenancy has 4 unities. They took possession at the same time. That's why they couldn't be joint tenants, Tim, because you didn't take possession at the same time because he added you later.
Right.
That tells me it was tenants in common.
Okay. 'Cause I need.
Now there may have been some language in there that said that you could sell, but that you had the right of survivorship, but you had it anyway.
Right.
Maybe the attorney put that in there just to be specific, so you knew that. Because for joint tenancy, you have to them guys all had to take possession at the same time.
Right.
They all had an undivided interest. They all did it, have a right to possession, and they all acquired the interest at the same time. You guys have tenants in common. You don't have to. You don't have to. A little bit confusing, huh, Ellen? Am I trying to make any kind of sense out of this?
It was real confusing, like, when I was reading ahead, but now you're explaining it.
Am I making it better, Seneca?
Yeah, like.
Christine?
Explain it, that's better sometimes than understanding it before.
Yeah, sometimes I don't even explain it right. I'm just faking it until I make it. But I think I'm on point on this, okay? But it's confusing even for me. Because number one is, as a real estate broker, I never deal with this. People come and buy a house. If they're not married, they usually take title as tenants in common. So when you buy a house, if you're not married, 2 people, they're tenants in common. Unless you specifically want to say, we want to do joint tenancy with the right of survivorship. Now, if you're married, automatically it goes to joint tenancy with the right of survivorship. Figure 6.3, combination of tendencies. A, B, and C take title as tenants, as joint tenants. Not joint tenants with the right of survivorship, just joint tenants. Okay? A sells his interest to D. D becomes a tenant in common, and B and C remain joint tenants. Now, the only way for that to work, don't get stressed, A can't sell to D unless B and C agree. So if they are joint tenants, if all 3 of them agree, one party can sell. But when A sold to D, he becomes a tenant in common. B and C still remain joint tenants. How do you terminate joint tenancy? Can be terminated by operation of law, which would be bankruptcy or foreclosure. Okay. Creation of a mortgage by a precipient. I'm not 100% sure what they mean by that. You can terminate by co-ownership by partial, by a petition suit. It's a legal way to dissolve a partnership when parties do not dissolve voluntarily. Okay.
Can you go back to terminating joint tendencies?
Yeah.
I just gotta write it down.
Terminating a joint tenancy can be terminated by an operational law. So joint tenants can be terminated by an operational law. Okay, if neither one of them pay their if they don't pay the mortgage payment, they can foreclose on them, terminate it, or if they went to bankruptcy. They can also terminate by partial suit. So let's say you and Vonnie are just joint tenants. Just joint tenants. Those guys are tenants in common, right? We should have a sign that says tenants in common. You guys are joint tenancy with the right of survivorship, right? So we know what happens with that. That's an easy one. With the right of survivorship, last man standing gets it. Tenants in common, you can sell your interest without the other party asking. You two guys are just joint tenants. You buy it as joint tenants. Now both of you have to sign the deed if you want to sell. So if Vonnie wanted to sell her interest and you didn't, then you have to go to court to terminate it. Because it's not joint tenancy with the right of survivorship, it's just joint tenancy. Okay, do you think sometimes people buy a house, they're not married, and they buy it as joint tenants, and they fall out of love and they want to sell the house? And Vonnie says she doesn't want to sell, and Lex says she does. Then you would have to go to court. If they were tenants in common, Tammy wouldn't have to ask Sheila permission. She could just sell her interest. And the joint tenants with the right of survivorship, they're not going to bust it up, because you only can be in that situation if you all take title at the same time. And in Pennsylvania, a special form of joint tenancy between spouses. It's automatically created when the owners are husband and wife. The inherited right of survivorship. Both must sign documents to convey property. So Seneca and Samantha are married. They have a special form of joint tenancy because they're married. So if something would happen to Seneca, Samantha gets the property. If something happens to Samantha, Seneca gets the property. If they want to sell it, they both have to sign the document. Samantha can't sign and sell her interest. That's reserved for married people. Okay. A little bit confusing. Hopefully you get through it. Hopefully I helped a little bit. Maybe we'll have a video that can help you. I don't know. What's that?
So like, how it says A sells her interest to D, and
Which one you on?
I'm on 93, page 93.
Okay.
Figure 6.3.
Yeah, these are joint tenants.
Okay, so if A sells her interest to D, but D will become a tenant in common. So say if
Why is that? Why does D become a tenant in common versus a joint tenant?
because
PITT. PITT. They didn't take possession. D is not taking possession title at the same time. A, B, and C took it at the same time, right? So now if A wants to sell, he can sell and D can take over, but D can't be a joint tenant.
right.
D has to be a tenant in common.
So my question was like, if B and C pass away, is the property going to remain in D, or does it, because it's not?
Well, B and C
Like
would
if
be
they
considered
die-
joint tenants.
If they die before D dies, will it remain with D, but being that but D is only a tenant in common, not?
Yeah, if B or C died, it may go back to one or the other on the joint tenancy. So if B died, it would go to C. If C died, it would go to B.
What if they
Yeah, that's what I'm saying, like, if they both died, then.
Well,
Rick
no,
left his
they don't.
deed.
They don't both die at the same time. If B would die, then C would be a own his share in severity. In
But he will
severity,
still be able to have their portion.
he would be in severity.
So he could will it to somebody. Or,
Yeah, I would guess. So termination of tenancy by entirety. Husband and wife control ownership. They transfer indebtedness as a unit. So the joint tenancy with the right of survivorship between spouses, basically they're just one entity. Does that make sense? Both of them have to sign to sell. Both of them would have to sign to get a mortgage on it, and so forth. So husband and wife control ownership. They transfer indebtedness as a unit, cannot encumber or convey an individual interest. So if they're married, can't get a lien against one without the lien falling on the property. They would be like one person. Can also terminate by the following agreement. If they execute a new